is back in session. The court is in session in two cases. Cause numbers 24-CCCR 2668 and cause number 24-CCCR 2870. Both cases are styled the state of Texas versus Anita Herbst Baird. We have Ms. Baird who is present in court. Ms. Baird, would you please raise your right hand? Ms. Baird, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Ms. Baird, you may put your hand down. Ms. Baird, you're represented in your case by your attorney Anita Provo. Attorney Provo, how are you doing? That's good. Marva Provo. Attorney Provo, how are you doing?
I'm doing fine.
You doing fine? Okay. And Ms. Provo, do you waive a record in Ms. Baird's case? Okay. Ms. Baird, how are you doing? That's good. Now, Ms. Baird, I have before me in cause number 24-CCCR 268, excuse me, cause number 2668. It's 24-CCCR 2668. Ms. Baird, you've been charged in this case with the Class B misdemeanor offense of criminal trespass, which allegedly occurred on or about October 7th of 2024 in Jefferson County, Texas. Ms. Baird, do you understand what you have been charged with?
Where was it at?
St. Elizabeth Hospital.
And October 7th.
That's today.
It must have been the time I was going there. I had pain in my stomach and they wouldn't see me.
Okay. Now, Ms. Baird, to this charge of criminal trespass, how do you plead? Guilty, not guilty, or no contest?
You just told me to discuss no contact.
No contest? Now, you pleaded no contest freely and voluntarily?
Yes.
And
I'm
are
a
you
bit
plead?
confused. I mean, why can't I go to the hospital when I'm in pain?
I don't know if they trespass warn you or not. Let's see, I can look at the
No, they
PC.
do several times.
Okay, hold on a minute. Let me
I'm
look at.
trying to get age sense, trying to get rid of sense. I mean, I plead no contest.
Okay, now you pleaded no contest freely and voluntarily?
Yeah.
And are you pleading no contest because you do not wish to fight or contest the charges?
No, I just would like another hospital to develop.
Okay, my question is, no contest means that you're not fighting the charges, and that's why you pleaded no contest?
Yeah.
Okay, now, Ms. Baird, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yeah.
Okay, on page 2 of this same document, there's a set of initials AB on a line next to a box that's checked no contingent, which means no contest.
Right.
Did you place your initials on this document? Okay, on page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes.
And on the next document, this document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
No.
Okay, on page 2 of this same, well, excuse me, at the bottom of this same document, there's a signature at the bottom that's titled defendant. Is that your signature?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
And the second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Yes. I also have another document that's titled Discovery Certification. Do you recognize this document? You can show that to her. And is that your signature? Okay, now, Ms. Baird, before you sign and initial all of these documents that I just showed you, did your attorney, Ms. Marva Provo, go over these documents with you?
Yes.
And did you understand everything that Ms. Provo went over?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
And Ms. Baird, are you a citizen of the United States?
Yes.
Stay
Okay.
up for states 1.
Any objections? No objections. State's exhibit number 1 will be admitted.
You voted.
Ms. Provo, you have advised and counseled Ms. Baird, is there any evidence that she's currently mentally incompetent to stand trial?
Not this time, according to Dr. LaFond.
Now, and the court is going to, the court has a psychiatric evaluation that was conducted by Dr. Edgar Rapon. In this psychiatric evaluation, he stated that the defendant was competent or is competent to stand trial. The court, now, Ms. Provo, do you have any objections to the finding, conclusions, and recommendations in Dr. Rapon's report?
No,
And state, you received a copy as well. Do you have any objection to the finding, conclusions, and recommendations in Dr. Rapon's report?
No objections, Your Honor.
The court will take judicial notice of the finding, recommendations, and conclusions in Dr. Rapon's report. Now, Ms. Baird, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her services?
Yeah.
Okay, Ms. Baird, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 32 days in the Jefferson County Jail, credit for 32 days to tax and retire on court cost, and this is to run concurrent with the companion case.
Ms. Baird, the state is offering that you serve 32 days in the Jefferson County Jail. You will not have to serve any more time in the Jefferson County Jail on this case because you've already served 32 days in the Jefferson County Jail. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. In this case, we'll run concurrent with the companion case, cause number 24CCCR 2870. Ms. Baird, do you understand the state's offer?
Yeah.
And do you think that the state's offer in your case is fair and just?
Yeah.
And do you accept the state's offer?
Yeah.
Ms. Baird, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Baird, I also have before me another document that is titled, in cause number 24CCCR 2870. And in this document that is titled information that was filed by the Jefferson County District Attorney's Office, it alleges that you, Anita Baird, on or about September 22nd of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Ms. Baird, do you understand what you've been charged with?
Where was that?
This was at the Medical Center of Southeast Texas.
Trying to get help again?
Yeah.
Okay, go ahead.
And do you understand what you've been charged with? Criminal trespass.
Okay.
Okay.
Where am I supposed to go to get?
No, listen. Okay, well, they, in this and as well as the last case, they asked you to leave and you refused to leave. That's what they're saying.
Oh, okay, I'll work on it.
Okay, now, do you understand what you've been charged with?
Yes.
Now, to this charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
No contest? Are you pleading no contest freely and voluntarily?
Yeah.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Ms. Baird, I also have before me a document that is titled misdemeanor plea admonishment, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yeah.
On page 2 of the same document, there are a set of initials AB on the line next to the box that says Chitnula Contingent, which means no contest. Did you place your initials on this document?
Yeah.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yeah.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yeah.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Ms. Baird, I take meant yes. Okay, now, Ms. Baird, I also have before me a document that is titled Discovery Certification. Recognize this document? And is this your signature on the line that's titled defendant? Now, Ms. Baird, before you sign and initial these documents, did your attorney go over these documents with you?
Yeah.
And did you understand everything that your attorney went over?
Mm.
And is everything in these documents true and correct to the best of your knowledge?
Mm-hmm.
Um,
Yes, sir.
State
okay.
offer states one at this time, Judge.
Any objections?
No objection.
No objections. States exhibit number 1 will be admitted. And Ms. Provo, again, you revising counsel, Ms. Baird, is there any evidence that she's currently mentally incompetent to stand trial?
No, no.
And Ms. Baird, Ms. Provo has advised and counseled you. Are you satisfied with her services? Are you satisfied with your lawyer?
Yes, very much.
Okay. And the court is going to state here, as stated previously, Dr. Edward Palmer was ordered to do a psychiatric evaluation. He did a psychiatric evaluation, finding that Ms. Baird was competent to stand trial. The court is going to adopt his findings, conclusions, and recommendations, and take judicial notice of it. State. Well, the court is going to accept Ms. Baird's plea of no contest. The court will find that Ms. Baird is competent to stand trial. The court will also find that the pleas and waivers was freely and voluntarily given. The court will also find that there is sufficient evidence to find Ms. Baird guilty beyond a reasonable doubt. State, do we have a plea
We do,
plea
Your Honor.
bargaining agreement?
We do, Your
And
Honor.
what is the agreement?
In exchange for defendant's plea, the state's offering 30 days in the Jefferson County Jail, credit for 32 days. This will also run concurrent with the companion case.
Okay, Ms. Baird, the state is offering that you serve 32 days in Jefferson County Jail. You'll be given credit for 32 days that you've already served. The court costs in this case will be taxed and retired. In this case, will run concurrent with the companion case, cause number 24 CCCR 2668. Now, Ms. Baird, do you understand the state's offer? Do you think that the state's offer in your case is fair and just?
Yeah.
And do you accept the state's offer?
Yeah.
Ms. Baird, the court is going to follow the plea bargaining agreement that you have entered into with the state. Ms. Baird, if you do not have anything else holding you in jail, you should be getting out of jail today. Ms. Baird, please stand next to the bailiff, follow her directions. Once you're finished, follow her directions. You can follow her, and you have a blessed day. as the jury comes in. You may be seated. Jefferson County Court, Law number 2 is now in session. The court is in session in cause number M332556. Case is styled the state of Texas versus Tyrone Lewis. Let the record reflect that Mr. Lewis is present in court with his attorney, Brendan Mitchell. State is present with Assistant District Attorney Andrew Hubel and Attorney Haley Simmons. State, are you ready?
State's right here.
Defense, are you ready?
Yes, Judge.
Members of the jury, the defendant, Tyrone Lewis, stands charged by information with the offense of being intoxicated while driving or operating a motor vehicle in a public place. The offense is alleged to have occurred, on or about the 25th day of November of 2021 in Jefferson County, Texas. The defendant has entered a plea of not guilty. Our law provides that a person commits an offense if the person is intoxicated while driving or operating a motor vehicle in a public place. A person is deemed to be intoxicated within the meaning of the law when such person does not have the normal use of physical or mental faculties by reason of introduction of alcohol, a controlled substance, a drug, a dangerous drug, or a combination of at least 2 of these substances, or any other substance into the body. A public place means any place to which the public or a substantial group of the public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. Now, if you find from the evidence beyond a reasonable doubt that on or about the 25th day of November of 2021 in Jefferson County, Texas, the defendant, Tyrone Lewis, did drive or operate a motor vehicle while intoxicated in a public place, you will find the defendant guilty. Unless you so find, or if you have a reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant. Unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted in evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. Our law provides that a defendant may testify on their own behalf if he elects to do so. This, however, is a privilege accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proven, the believability of the witnesses, and the way to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the case. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page of this charge is the verdict form. If you'll notice that there are two sections, one at the top and the other one at the bottom. The one at the top states, we, the jury, find the defendant not guilty as charged in the information of driving while intoxicated. If that is your verdict, then your foreperson will sign on this line at the top. Then it says, or we, the jury, find the defendant guilty as charged in the information of driving while intoxicated. If that is your verdict, then your foreperson will sign at the bottom line, on the bottom line. Does everyone understand? Okay. State, are you ready? Defense, are you ready?
Yes, Your Honor.
Okay. The state has the right to open and close. Each side will be given 30 minutes for a closing argument. State, you may proceed.
State lays its right to open, reserves its right to close, Your Honor.
Okay. Mr. Mitchell, you may
Yeah, Your Honor.
proceed.
Just have just a moment to get set up here, Judge.
Yes, okay. And I'll keep the time. Just
Thank you. If this court.
yes.
Thank you, Judge. Good afternoon, ladies and gentlemen of the jury. Again, my name is Brendan Mitchell, and I want to apologize to you for how many days you had to be here. Some of you were excited about jury selection. We are ventured to guess and kind of regret that decision at this point. Make this as brief as possible for you. So you just heard that the entire charge was given to you. First thing I want to touch on that charge is it's your duty as jurors to make sure that justice is done. Now, justice has many meanings. Might be a guilty verdict, but it could certainly also mean acquitting an innocent man. So the state has the entire burden of proof. I'm going to run through this jury charge with you real quick. On the first page, it says introduction of alcohol. You'll get a copy of this to take back with you. But it says loss of mental or physical faculties due to the introduction of alcohol. Has to be 100% or whatever you take beyond a reasonable doubt to mean that it's the alcohol that caused that solely on its own basis. Moving through to page 3. Presumed to be innocent. So I talked about early on in opening and in jury selection, everyone in the United States and in this state of Texas is presumed innocent. We are clothed in that presumption of innocence. It is the state's burden, 100% on their shoulders, to get you somewhere else beyond a reasonable doubt. It goes further to say the presumption of innocence alone is sufficient to acquit the defendant. That's that part I was talking about in jury selection, where I could sit over here and absolutely say nothing, because the presumption in and of itself is enough to acquit someone. If the state fails to prove to you beyond a reasonable doubt, you must acquit the defendant. In this state, or in this case, the state has completely failed to meet that burden. And you see that when you go to the video evidence that was submitted to you. Okay? They brought 2 officers, arresting officer and an officer who showed up later who didn't see anything on the scene. This is an at time of driving state. What that means is they have to prove to you beyond a reasonable doubt, and we'll go back to reasonable doubt in a moment, that Mr. Lewis operated that vehicle while intoxicated at that time. You have to ask yourself, what evidence did they bring to you to show you at time of driving? The officer showed up well after the accident. There was a caller, somebody called in an accident. because dispatch got it. They didn't witness it. Somebody witnessed it and called it in. There was never an allegation that that person who viewed the accident saw Mr. Lewis speeding, swerving, driving erratically, any form or fashion. Then you get to the officers on scene, and you heard from Officer Taylor that he saw these signs of intoxication. He saw slurred speech, or heard slurred speech. He saw fumbling around with the wallet and the ID. He saw or heard inconsistent statements. He saw someone who appeared to be confused, answering questions differently. You also heard from Officer Taylor. He talked to the medical staff on scene. They believed possible concussion. They already had Mr. Lewis in a collar. They took him to the hospital for a CT scan, found out he hit the steering wheel so hard that he actually had short-term memory loss about actually getting into the wreck. He had bones in his eye socket cracked. His jaw was cracked and pushed back. Significant injuries, blood on his face, stumbling around at the hospital, mumbling, complaining of a headache, forgetfulness. You heard these things from the Mayo Clinic. You heard that the officer had no reason to dispute those things from the Mayo Clinic. When you watch that video, you'll also see at the end of it on Officer Taylor's body cam that was admitted into evidence, and you can take a look at it. There was a blood draw for the purpose of DWI. Where is it? You have to ask yourself, where is that biological evidence? If it's not here, you gotta presume it didn't have anything that showed intoxication. That we start. Remember the puzzle pieces, right? Make this into puzzle pieces. We know that the main piece that's missing is any biological evidence or any testing that shows intoxication. We don't have a finger test, the 1, 2, 3, 4, 4, 3, 2, 1 that's in their manual. We don't have the modified Romberg. Put your head back, close your eyes, guess how much time elapses or count to 30 seconds. We don't have that. That's in their manual. We don't have ABCs, say it without singing it. That's in their manual. Count backwards from this number to this number. That's in their manual. We don't have those things. We had zero investigation by Officer Taylor. Watch the video. It's 20, maybe 30 seconds, I'm guesstimating, from the time he starts talking to Mr. Lewis to the time he walks over to Officer Carr and says, oh yeah, he's intoxicated. By what? By what you think you saw? The man, highway speeds, hit his face against a steering wheel with no airbag. We know those are signs and symptoms of a concussion. They didn't bring any medical expert in. They didn't bring any lab expert in. No one to argue the fact or to differentiate those signs and symptoms. Now we talked a little about in Board R about the burden of proof necessary to take your children away in CPS. It's called clear and convincing evidence. Now you heard some of your jurors and some of yourselves say that you would want your jurors on either side of you to be very certain. One of you said 100% certain. If that's what clear and convincing is to you, you have to be more certain than that to get to reasonable doubt. You can be clearly convinced someone did something wrong in the state of Texas. But if the state failed to meet their burden and you have a question as to the probable cause for arrest, as to the signs and symptoms the officer testified to, as to what the blood would have been, right? Where's that evidence? Those are all reasonable doubts. Those are all those questions. We talked about reasonable doubt. Another way to say it is past one rational question. Those are some pretty rational questions in a case where we're talking about taking away Mr. Lewis's freedom, labeling him a criminal with that scarlet letter on his chest for the rest of his life, because that's what a DWI is in Texas. It never comes off your record in the state of Texas. About wrong way. Or I thought about Rick a little bit, but you guys helped me out a little bit. And one of the things he's most famous for saying is the 9 scariest words in the English language are, I'm with the government, I'm here to help. And he also said, trust but verify. They brought the government The government testified and said, I have no evidence whatsoever other than my personal opinion, no medical training, but I want you to trust me because I'm with the government. But he showed you nothing to verify his suspicions. He even said, when he talked about, oh yeah, he's intoxicated, I said, officer, you said for sure you believed him to be intoxicated. You can't let someone go free. So that was at the time you decided to arrest, right? Because I was leaning that way. I got to reasonable suspicion. Reasonable suspicion's down here, below probable cause. He never even testified he got to probable cause. We've been here for 4 days. Your time, my time, Mr. Lewis's time, the court's time, with absolutely no evidence. It's pretty shocking. Slurred speech, lethargic movements, confusion, all signs and symptoms of a concussion. The officer said no odor of alcohol because he was recovering from COVID and lost his sense of smell and taste. Could have happened. I had COVID several times. I didn't lose mine. I know some people did. But we had another officer who didn't claim to be sick. She was in a hospital room without any fumes of cars on the interstate or anything else. Clean environment. She never said anything about an odor of alcohol in her testimony or in her report. Watch the video. The nursing staff and the medical staff never says anything about an odor of alcohol. So maybe it just wasn't there. Because maybe he didn't drink anytime close to driving. He was confused about time. He didn't even remember getting in the accident. But they want you to convict someone because they had a couple of drinks at some time prior to driving, and we don't know when. They don't know absorption or elimination phase. They don't know what the contents of the stomach were. If it was greasy food, not greasy food, because that's how alcohol gets into the system. It's going to be slower in the abdomen and then get into the small intestines. So it takes longer to digest that food and get into the small intestines. No medical testimony whatsoever to get you there. The second car issue. We know dispatch believed it to be a second car. Somebody saw it. Somebody said something. What can we do with investigation? That's pretty easy. There's tire marks. There's yaw marks showing how fast the car was going when they turned and what portion of the tire was leaving a mark on the road. That's all part of accident investigations. And if someone just immediately swerves into the wall, probably somebody coming into their lane. And if that's the fact, and Mr. Lewis avoided a collision with another car, that's pretty good mental and physical faculties driving at highway speeds. They didn't even go look for any cameras along the side of the highway from any gas stations or other businesses that might have seen that area of the roadway. Didn't bother. There's an old saying, it's better to let 1,000 guilty men go than to convict one innocent man. So I'll leave you with this. You have to ask yourself one question: what you're more afraid of? Are you more afraid of letting someone who might, on a slight chance based on that officer's testimony, be guilty go? Or are you more afraid to convict an innocent man? I know it's going to keep you in the dark. Thank you for all your time throughout these 4 days. I trust that you'll make the right decision. I trust that you'll find Mr. Lewis not guilty.
Yes.
I want to first start off by thanking you all for your patience and attention this week. As Mr. Mitchell said previously, it has been a very long week, and I can't thank you enough. The citizens can't thank you enough. Both the court and defense can't thank you enough for your attention in this important matter. There have been a few stopgaps in the course of this proceeding, but those were made with the purpose of ensuring that this trial was a fair and just one, and I appreciate your patience and consideration. But now that trial has reached a critical point, and you all are being asked to make a decision, a unanimous one, as to whether the defendant, Mr. Jerry Lewis, is guilty of the offense of DWI. And the state has met its burden beyond a reasonable doubt in this case. I'll go element by element just to illustrate how the state has proven beyond reasonable doubt. And I will give you the exact evidence that you can look to, because you have access to the testimony and the exhibits in the trial for further review if need be. I'm going to show you exactly which evidence points to each element being proven beyond reasonable doubt. Addressing the element of the offense taking place in Jefferson County, Officer Taylor's testimony places the activity at Edinburgh Boulevard in Port Arthur, Texas, which is in Jefferson County, Texas. This is also a public place. It's a public road. The video in states one would also prove this element. The offense taking place on November 25th, 2021, Officer Taylor's testimony of the date in which he responded, as well as Officer Fair's testimony of the date in which she responded to the hospital, proved this element, as well as the defendant's own recollection after some continued questioning. When he was at first confused, he then remembered it was Thanksgiving, November 25th. This is found in State's Exhibit 1. And now, the defendant has been identified as the defendant, Terrence Lewis. The officers, both Taylor and Fair, identified the defendant in court, and you can also see in both videos, State's Exhibit number 1 and number 2, that is in fact the defendant, Terry Lewis. Operation of the motor vehicle. Taylor's testimony places the defendant, Terry Lewis, behind the wheel of the vehicle that was found on Memorial Boulevard, the vehicle that was involved in the accident. He was the sole occupant of that vehicle, and he was in the driver's seat. This is also seen in State's Exhibit number 1. And the defendant himself in State's Exhibit number 1 makes admissions to crashing into the concrete barrier that's admitting to operation of the motor vehicle. Intoxication. Officer Taylor's testimony, he testified to several signs of intoxication he saw. And Mr. Mitchell mentioned these in his closing: very glassy eyes, slurred speech, confused demeanor, heavy uncoordinated movements, memory loss. Officer Fair also testified to these signs as well: slurred speech, sluggish movement. She used the term wobbly. Incoherent speech, difficulty answering questions. There was the incident that you can see on State's Exhibit 2 involving the urinator. And there's also the fact that an accident occurred. Vehicles don't simply drive themselves into concrete barriers. That's just not something that happens on their own. You can, in regard to the signs of intoxication, you can see the signs that Taylor testified to on State's Exhibit number 1, and the signs that Fair testified to on State's Exhibit 2. The defense's argument amounts to the signs of intoxication that these officers have testified to being the result of an injury from an accident, rather than that intoxication. That injury does not preclude intoxication. And further, there's an issue with that explanation, that excuse. It's that the defendant, Mr. Lewis, admits to drinking alcohol several times to both responding officers. This can be seen in their testimony as well as in the exhibits, States 1 and 2. In regards to consumption of alcohol, his story changes over time. The location of the drinking changes. At one point, it's a corner store on 9th Avenue. At another point, it changes to when he was with family. And that makes sense because it's a holiday. It's Thanksgiving. And it's very common for individuals to drink in excess on holidays whenever they're enjoying the holidays with their families. This is a common occurrence. He also testified to the amount that he drank, which fluctuated from 1 beer to a couple beer, sometimes to more. And he even at one point says that he drank it as recently as 30 minutes prior to the incident. And while those things were changing, one thing is certain on that night, Mr. Lewis felt that his drinking was the thing that was to blame for the accident and all of it.
Objection, Your Honor. Approach.
Okay, ladies and gentlemen, can I ask that you disregard the last statement that was made by the prosecutor, and it will be stricken from the record. And ladies and gentlemen, questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. Mr. Huber, you may proceed.
Thank you. So I would implore you to review State's Exhibit number 2. There's an instance that I think is of particular importance that about 7 minutes into that video. And you may need to listen very closely to that portion of the video. The sound is fairly low, but I think it is very vital to this case that you review that specific exhibit at that time. No. I think it's clear based on the testimony and the exhibits in this case that the defendant's normal use of his mental and physical faculties were compromised by the introduction of alcohol. Something that he admitted to doing. He admitted to drinking alcohol several times to both the responding officers. And he made the decision to get behind the wheel knowing he was impaired. And that endangered others. It ultimately resulted in himself being injured. We're fortunate that it was only Mr. Lewis that was involved in this accident, and that his injuries did not cost him his life. But that's why it's important that we have laws that criminalize this conduct to prevent accidents, to prevent injuries, to prevent potential loss of life from happening. And especially around the holidays, these kinds of things are very important. And it's why I think it's important that you hold him accountable for his actions, that that he admits to several times on the videos on State's Exhibit 1 and 2. Defense claims that there was no evidence to support a finding of guilt in this case, but I have shown you going element by element the evidence that the state has provided that proves this case beyond reasonable doubt. I ask you that you make a careful review of the evidence, the testimony, and the exhibits in this case, and hold the defendant to his own words that he says on those exhibits. Hold him accountable for his actions and revert a true verdict of guilty. Thank you. Thank you again for your patience and your attention this week.
Okay, ladies and gentlemen of the jury, both the state and the defense have concluded with their closing arguments. And before you go into the jury room, I must inform you that one of the jurors here is an alternate, and the alternate is not allowed to go into the jury room. The alternate will be available if one of the jurors is not able to complete the negotiation, to complete the deliberations. And so the person that is the alternate in this case is Alan Eugene Pruitt. And Mr. Pruitt, you can either remain in the courtroom, or if you like, you can sit outside the courtroom. And Ms. Bailiff, I have the charge that I'm going to give to you. And you can hand that to, well, you can bring that to the jury room with the other jurors. Okay, everyone, please stand as the jury exit and go into the jury room. Court will be in recess until we get a verdict. Mr. Fruit. Okay, let the record reflect that the court is back in session. Court is in session and call number M 332-556. Case is style of state of Texas versus Terrence Lewis. Let the record reflect that Mr. Lewis is present in the courtroom with his attorney, Attorney Brennan Mitchell. Let the record also reflect that the state is present with Assistant District Attorney, Attorney Andrew Hubel, and Attorney Haley Simmons. I have received a message from the jury that it has reached a verdict. Will a bailiff please bring the jury into the courtroom? You may be seated. Let the record reflect that the attorney for the state, the attorney for the defendant, and all members of the jury are present and seated in the courtroom. Okay, four-person, have you reached a verdict in this case? Is this verdict unanimous? That is one that is agreed upon by all the jurors.
Yes.
Please hand the verdict to the bailiff, deliver to me. Four-person, is the verdict unanimous verdict of all members of the jury? Okay, you may be seated. Mr. Lewis, would you please stand? We, the jury, find the defendant not guilty as charged in the information of driving while intoxicated. Okay, Mr. Lewis, you and your attorney may be seated. We have some letters for them. Letters. No.
Yes.
Okay. Ladies and gentlemen of the jury, first of all, on behalf of the citizens of Jefferson County and a staff here in County Court at Law Number 2, I'd like to thank you for your time and attention that you spent on this case. I know that during voir dire, we said it was a misdemeanor case. Maybe some of you thought that it probably was going to take a few minutes or an hour or so, and I'll be gone home. But you know, in cases like this, I think Mr. Hubel said it well when he said that a lot of the delay was to make sure that the defendant received a fair trial. Okay, and again, I'd like to thank you for your time and attention that you spent on this case. And as I mentioned to the individuals who was on the panel who did not make the jury, anytime that you're in this area, Jefferson County Court at Law Number 2, you can come and have a seat in your courtroom. And the reason why I say it's your courtroom, because I'm only an elected official serving the citizen, which is you, of Jefferson County, Texas. And this is your courtroom, so anytime that you're in the area, you can have a seat in that area we have out there behind the wall. We call the peanut gallery. And as I mentioned earlier, you can't burn peanuts in here and eat because this is not the Texas Roadhouse, but you can come and have a seat in your courtroom and just see what goes on in Jefferson County. Your jury service is complete. You can take your badges off and you can put the badges on the counter. If you need any type of excuse or if you need anything from our district clerk's office is right across the hall. They'll be happy to give you whatever you need. Again, thank you for your time and attention. And as I also mentioned, I usually give everyone a handshake, but we still have COVID in our community. And however, I will give each and every one of you an air handshake. Okay. And again, thank you for your time and attention. And each and every one of you have a blessed day and a happy holiday. Okay, the bailiff had some letters for you. Now, let me tell you this here. You can talk to, the lawyers might want to talk to you. You can talk to them if you want to. If you don't want to talk to them, you don't have to talk to them, okay? So at this time, Ms. Mosby she has some letters for you. Thank you for coming, and y'all have a blessed day and happy holidays.
Appreciate that. Thank you so much. I'm sure y'all probably don't want to hear either one of us talk for the rest of the night.
Okay,
I'm not next week.
and this will conclude the trial in County Court at Law Number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. Prosecutors and the attorneys, you're excused, and you have a blessed day.
Thank you.